It's 7:34 p.m. on September 5th, 2021. It's almost sunset. And I am going to give a very quick order. I will start this by saying in 2017 I contacted the Supreme Court of Texas. Among other things, I discussed the need for evaluation of the Texas Economic Development Bank, as well as information regarding any sort of defense readjustment project that was ongoing in the state of Texas. And this was following contacting the Texas Veterans Commission as well as the Texas Health and Human Services Commission, following already contacting the Texas Medical Board as well as the State Bar of Texas regarding my concerns that, among other things, children, including children of military dependents or children of military veterans, were being abused through the Health and Human Services system, specifically in regards to forced medication for ulterior motives. What I did not know at the time is that the summer of 2017, up through September 1st of 2017, would have been the 10th anniversary of changes that had been made in law in the state of Texas during the 80th legislative session, specific to matters related to children of members of the military, as well as other things associated with the military. During the 80th legislative session in the state of Texas, there were several bills passed. SB 962 regarding school districts and relationship with children of the military. SB 1237 regarding a defense-based development authority. SB 1724 regarding the Texas Military Facilities Commission. SB 1743 regarding the Red River Redevelopment Authority. SB 1956 regarding areas affected by defense restructuring. SB 1956 areas affected by SB 1956 areas affected by defense restructuring, and HB 3879 defense-based development authorities. These were bills that went into effect by September 1st of 2007, which means the 10th anniversary would have been 2017. To my knowledge, there was no report on these. And the efforts I made to try to contact people about things that I had observed real time at the time were subjected to grotesque violations and abuses that unfortunately I understand are reflected in the alleged current session, and the abuses that have occurred during the alleged current session that have put Texas and other people, by virtue of their relationship with Texas, in a very precarious position. First of all, I want to address matters related to HB 1521, which references House Joint Resolution 7 concerning the authorization of a $250 million general obligation bond for the Texas military regarding a value revolving loan account. I believe a full audit is needed in regards to this bond specifically, as well as how to discussion on how to either refinance it as a non-revolving loan or use that audit and the results of that audit to finance new bonds of the equivalent amount or more. What happened to that $250 million general obligation bond series that was authorized for the Texas military under HJR 7? It's a lot of money, $250 million. My understanding is that one went into effect for 2005 after it was approved in May of 2003, which means by the time these changes took effect on September 1st of 2007, it had already been bonded to a $250 million bond. And during the 2007 legislative session, there was authorization for more bonds. That first bond, or that $250 million bond, is going to be very important. It's also going to be very important to know who authorized it, as we will see going through here. In July 2017, there was flooding announced, or there was an announcement that there had been a flood at Fort Hood outside of San Antonio. And there was all of these newscasts showing people in pontoon boats with water that went up past the top of their cars, or nearly to the top of their cars. And presumably, there was a need to evacuate members of the military stationed at that military base. What happened as a result of the declaration of a state of emergency in July of 2017 here in Texas prior to Hurricane Harvey? We need to have a full assessment of whatever happened as part of that response, including any FEMA or federal assistance, as well as any assistance the state of Texas provided, and what that had to do with any outstanding obligations, including ones that had been pending for 10 years by the time of that event. In regards to other things here, there was in September 1st of 2019 changes to Texas law regarding licensing. Not only licensing for civilians, but specific license changes regarding people who had specific military operations specializations in terms of their active duty service that were attempting to get some sort of certification or licensing with the state of Texas. It was alarming insofar as that those civilian specializations were also paired with comparable military specializations. These went into effect on September 1st of 2017, despite the fact that at the time there was alleged to be a state of emergency declared. What is the status of those license changes? And how do they correlate with the proposed objective number 6 that had been proposed as part of the legislative session in 2008? Legislative session of 2008 as the first annual follow-up report to the changes that took effect on September 1st of 2007. The understanding is that there was a report provided within 1 year of the engagement of these policies by the Texas legislature. What has happened since then? Regarding SB 962, there's a discussion of a 25% reduction in per student amount provided to children who were members of families associated with the military. Among the things it says is that the state can provide assistance to those children in the need, in the understanding of a shortfall. This is incredibly alarming. Why was the state of Texas allowed to devalue students who had a family member in the military by 25% and then offset whatever the need was with state assistance? We need an audit of every single school district that had students that were devalued by 25%, as well as an audit of every single contractor with the state of Texas that provided any of that assistance that the state provided to any of those children of the military for all 10 years up to and including the 4 years that have commenced since the 10th anniversary. This would have been part of what would have been required as an adequate response in 2017, when I contacted first the Texas Veterans Commission and then the Supreme Court of Texas. This would have been the least to have been provided. It was already legislated, which means the state of Texas, including the members of the legislature, already knew it was law. It was law that it had gone into effect to do these things, and as per the terms of the rest of the pieces of legislation outlined here and what they commit to, so too would be a follow-up review up to and including an audit. Regarding 1237, SB 1237, what ports specifically and what countries specifically were authorized as part of these plans? We need a full audit of all transactions as well as any contracts with the state that were hooked up in association with SB 1237 of 2007. What were the federal congressional approvals? The state of Texas can say that it wants to engage in commerce with other countries. But insofar as there were any treaty relationships that were established, treaty terms are decided by the federal government. What were the federal authorities backing up anything Texas said it was going to do in connection with SB 1237 of 2007? Regarding teleconferencing, we need to cross-reference any elements of SB 1237 regarding teleconferencing with the Texas Health and Human Services Code concerning telemedication and reimbursements, including via Medicare, and identify any common carriers as well as any contract awards or potential abuses through a form of kickback, including but especially in association with Texas's relationship with the Children's Health Insurance Program. This also needs to be addressed contemporarily with federal legislation regarding COVID and any sort of work at home requirements or permissions. What funds were identified as being allowed for inculcation into the elements of SB 1237? We need a full audit. Regarding changes to section 431.030, both before and after changes, what was the real property of concern, including the owners and any taxes? If there were any donations, those donations would have needed a receipt, and they would have needed an assessment of tax value to be provided as part of that receipt. We need a copy of all of those receipts, and we also need an assessment of all that was allowed to be valued as part of those donations to the Texas military. As of 2017, there is no info as of 2017, there was no information provided to me by the state of Texas regarding who was the adjutant general or what the adjutant general was doing during the alleged state of emergency that was declared either in July or later in late August through early October of 2017. Additionally, on September 1st of 2019, there were specific changes to the Texas Military Code regarding the role of the adjutant general. I am on the record and currently pending in consideration of significant unconstitutional changes to the law that were made in the state of Texas regarding for implementation beginning September 1st of 2019, specifically regarding confidentiality of information related to contract bidding, as well as any sort of attempt at litigious process or any sort of proceeding against a political subdivision that are blatantly unconstitutional. Just as the laws were changing regarding the role of the Adjutant General, the state of Texas decides it's going to engage in these kinds of unconstitutional changes to legislation, this needs to be evaluated per the terms specifically of obligations incurred by the Adjutant General that were not appropriately responded to within 10 years of implementation. That means the Texas Public Finance Authority, along with the comptroller, needs to issue an audit of all revenue bonds that were approved per changes to section 431.0302C. What property was transferred to the state? When? Who authorized it? What about disposal? Any property that was disposed of? What were the components or the successors consulted per section 431.0302? We also need an audit of all applications of section 431.0305E, including and especially anything from May through November of 2017. We need an assessment of all lost tax revenue to various political subdivisions per section 431.0306 and information on how the costs were offset or covered otherwise. We also need an audit of section 431.0292 of all borrowed money, including who provided the surety or what was used as collateral. This is for the entire 10 years up through 2017, as well as anything that happened from 2017 until now. According to Section B, all bonds are approved by the Attorney General. That means every single bond has two authorities that need to be audited, and then those audits, independent of each other, need to be compared with each other. The Attorney General's office, as well as the specific commissions or the specific entities cited in the legislation. Where are the audits for former Attorney General Cornyn, former Attorney General Abbott, and former Attorney General Paxton? To this time, they have not responded. We need a full report on Real Property Advisory Committee per section 431.0294. The Texas Public Finance Authority as owner during transfer. Where is the info on the status of them as a potential legal pass-through, including any relationship to Fannie Mae or any other agency as such bonded? You know exactly what I'm talking about. Go back to December of 2019. Section 12. What then is the process for the Adjutant General to report to legislature and real property determined to be for the military use? You do not by law have the authority to say the Adjutant General does not have to provide any form of report to the Texas legislature insofar as it's being used for any military purpose. Even insofar as he would have to report to the governor, there would have to be an accountability structure through which the legislature could hold the governor accountable. Where is it? It's not constitutional to have no report. Regarding section 1232.101, we need an audit of all bonds provided to state agencies, including refunding bonds and their current status. Regarding subchapter C, chapter 1232 of the Texas Government Code, issuance of bonds for military facilities. This would require both the specific commission authorized to provide these bonds as well as the Attorney General. We need that board. What is the specific board that's being referenced here? There is a decommissioning of one board and a recommissioning of one board. This is comparable to what happened in 2017 with the State Bar of Texas and the Texas Medical Board during the sunset review period. We need a distinction, and you also need to check the Attorney General opinion, which I've already provided reference to, discussing how, even though there may be a name change, the commission or the entity after the name change is still responsible for what happened before and prior to the name change. We need a closeout report on any abolition of Texas Military Facilities Commission operations, as well as a procedure for the Adjutant General to take on responsibility outlined in Section 17, subject to Section 431.0307 of the Government Code. These things were in effect as of September 1st of 2007. Now, there is more, and I'm going to try to bring that up quickly regarding SB 1956, specific report and inquiry into ramifications of Section 486.001 in Texas Military Preparedness Committee. This is what I'm talking about. One commission was decommissioned and another one was started. There is no real explication of what that transition is, but it does not disobligate the state from taking responsibility from the implications of those commissions, including the one being decommissioned and the new one being commissioned. All list of awards under the Texas Military Preparedness Committee, authorizations and status, including reporting requirements, need to be cross-referenced with reports from the auditor's office, up to and including SAO 17-043. There is still an outstanding request for the auditor of the state of Texas to respond to a reissue on that audit report in 2017. That is one of a number of reports from the state auditor's office that need to be cross-referenced with these specific changes to the law. We also need to cross-reference section 486.005 with records from the Texas Insurance Commission. The inquiry hearing of concern must be scheduled within 30 days per the Texas Insurance Commission, which means starting tomorrow, September 6, 2021, we need a formal commission inquiry hearing on site with people in person within 30 days of September 6, 2021. We need an audit of all grants, as well as information on all grant applications and the vetting processes for those applicants. Who are the approved bond agents for grants that are authorized under the Texas Military Preparedness Committee? Regarding HB 3879, we need to have an explication of specifically what is the details and the determinations regarding eminent domain and authorization for eminent domain. It says Chapter 21 of the Property Code is the only one under which eminent domain can be applied. What are the criteria for condemnation, and or what are the terms for compensation in the event of an acquisition? We need an audit of all payments for acquisition through eminent domain and or all terms associated with any sort of condemnation in order to acquire property through eminent domain per section 379B.0045. Finally, for the purpose represented above, I decline to authorize section 379B.0085 regarding hearings by telephone or similar means for this proceeding. Transportation to and from the meeting will need to be assessed for appropriate verification, insurance, and bond, including in connection with the state. Transportation to the meeting such as this is going to be very important in order to assure that there are no misrepresentations that this meeting or anything concerning this particular hearing or this proceeding could be used in order to try to undermine the state any further. It is 7:51 p.m. on September 5th, 2021.